Hello all. In this video, I'll brief you about the development of the Supreme Court yesterday concerning criminal procedural law and its impact during the COVID-19 lockdown that we are currently. So, what happens is a former Director General of Police of Uttar Pradesh, Dr. Vikram Singh, he filed a writ petition before the Supreme Court under Article 32 of the Indian Constitution. Now, the context is, as all of you would know, ever since the lockdown and other social distancing measures, have been issued under the Disaster Management Act and the Epidemic Diseases Act as well, the police have been filing FIRs against the people who have violated those guidelines, especially under Section 188 of the Indian Penal Code. 188 is only one of the main provisions. There are other few criminal offences which are governed under the Disaster Management Act, which can be sort of charged against such violators. Now, Section 188 of the IPC deals with disobedience to orders duly promulgated by a public official, like a public official, like a police commissioner or a district collector or a chief secretary to the state, etc. Now, the petitioner, Mr. Singh's argument is that FIRs under Section 154 CrPC cannot be filed for a crime committed under Section 188 Indian Penal Code, and therefore such FIRs which have already been filed should be quashed by the Supreme Court, should be sort of cancelled by the Supreme Court. So my task in this video will be to sort of explain why this argument by the petitioner is legally incorrect and why that prayer must not be granted by the Supreme Court. So this video is, I think, mainly directed at law students, as there will be a lot of technicalities being discussed. But still, I hope non-lawyers will also sort of try and understand it. So, getting to the meat of the discussions, the petitioner mainly relies on Section 195 of the CrPC to argue that no FIRs can be registered under Section 188 of the Indian Penal Code. So, to give you a sense of what 195 CrPC is about, it deals with the procedure to take cognizance of offences by judicial magistrates. Judicial magistrates, if you know, are form the sort of the main bedrock of the judges, the courts of law at the district levels in every state. Now, 195 specifically talks about cognizance taken by such magistrates in such cases where there is a disobedience of orders passed by a public official. And it says that the magistrate can take cognizance of such an offence only on the basis of a written complaint by the concerned official whose orders were violated by that particular offence. Right? Now, and as Section 188 is such an offence, as I mentioned earlier, the petitioner states that the machinery of criminal justice for a crime under 188 IPC has been set in motion in the last few weeks by filing FIRs instead of filing a complaint before the magistrate as per 195, and which, filing of FIRs, which he says is not at all permissible in view of the plain reading of the Section 195. Now, essentially the petitioner states that Section 188 of Indian Penal Code must be read with Section 195 of the CrPC, which mandates that a magistrate can take cognizance of an offence under 188 IPC only upon a written complaint by a public official. And therefore, the petitioner submits that these FIRs which have already been filed are an antithesis to the CrPC and is grossly illegal and is also an antithesis to the rule of law and violates Article 14 and 21 of the Indian Constitution. All right. So let me write it in bold and in an underlined format that this argument is patently wrong. Speaking technically, a reading of Section 154 should tell us that an FIR can be registered in all those crimes where the crime is considered as a cognizable offence. Now, for a brief understanding, the CrPC creates two distinctions. All crimes that are regulated by the IPC as well as other criminal laws are classified into two categories. Either they are cognizable offences or they are non-cognizable offences, right? Now, in the CrPC, this is not done using a strictly identifiable standard according to me. However, generally, all crimes which are considered to be serious in terms of their punishment or, in terms of their general impact on the society and its institutions are considered as cognizable offences. Now, the consequence is the moment a crime is considered to be a cognizable one, the police gets more powers, like they can start an investigation into it without the magistrate's approval, and the only way in which the police can start an investigation officially in a case is by filing an FIR, right? So section 154 is attracted if the crime is a cognizable, and in cognizable cases, in fact, the police can even arrest the accused person without the magistrate's warrant. None of this is possible if the crime is a non-cognizable one. Now, the question is, where do we know whether a crime is a non-cognizable one or a cognizable one? How do we know whether section 188 is, either of those? There is a ready referencer in the form of the first schedule in the CrPC, which tells you about the same. You can clearly see that if you open the first schedule and see the listing, section 188 of the Indian Penal Code is put under the table of cognizable offences. As 188 is a cognizable offence, the section 154 becomes applicable and the police can legitimately file an FIR. Therefore, the petitioner is clearly wrong on that front. I would say it is highly unfortunate that a writ petition filed by a former police officer at the highest level of a DGP does not even cite the first schedule of the CrPC, which is one of the most important parts of the CrPC. Now, last point, the petition is also incorrect, in terms of the interpretative use it makes of section 195 of the CrPC. Now, mind you, section 195 CrPC does not regulate the initial stages of a case like filing of an FIR once the crime is alleged to have been committed. It talks only about this process called cognizance of the cases. And by the way, there is, symbolically speaking, there is some distance between FIR and cognizance in a criminal process, right? Now, to give you a brief idea about what is cognizance. Cognizance of criminal cases in the CrPC is one of the most critical stages in a criminal case, because this is the first time a court of law, usually the judicial magistrates as we spoke earlier, take official notice of a case in order to proceed with that case for a criminal trial to find the guilt or innocence of the accused. Section 195 does not talk about FIRs and its possibility or its impossibility at all. The relevant provisions that govern the law on FIR are section 154 and the first schedule of the CrPC. These two provisions are enough to determine whether an FIR is possible in a particular case or not. The bar under section 195 to have a written complaint from the public official concerned, to take cognizance for the offences under section 188 IPC will not prevent any police officer to register an FIR and investigate that. In a crime like section 188, I'll tell you this is what practically happens. So, once the police registers an FIR, let's say, they will investigate the matter, then they will file something called as a charge sheet. And this is done under section 173 of the CrPC. This charge sheet is submitted to the judicial magistrate for the purpose of taking cognizance. So this is that distance between FIR and cognizance that I was talking about. And when the police files a charge sheet under section 173 before the judicial magistrate, it is at this particular stage, along with the charge sheet, that is where the public servant or the public official, who had issued those orders which were violated by the people who were, then charged with section 188, that public official will need to sort of submit a written complaint that is mandated by section 195. It is at this particular stage. For instance, let us take an example and sort of understand this flow. So let us assume that, something that is common during this particular lockdown period. Let us assume that it is, the district collector of a particular district who has issued an order prohibiting the gathering of more than 5 persons in a particular town, let's say. Let's assume that you violate that same order by going out with your friends at that particular prohibited time. Then what happens is that the police will file an FIR under section 188 against you. Then after relevant investigation, if at all it is necessary, they will file the charge sheet. Then the district collector will have to additionally attest that charge sheet by the police with a written complaint. In the written complaint, he or she, the district collector, will sort of state that yes, I had issued such an order prohibiting gathering of more than 5 persons, and the police have reported that these 7 persons have violated that particular order. Thus, the claims in the charge sheet are valid to prosecute the accused. Thus, to initiate police proceedings before this stage, mind you, before this particular stage, there is no necessity for a written complaint. It is only from this stage onwards for the case to proceed. That is where you need the sort of the extra level of attestation by the public official whose orders were violated by the lockdown violators. So that's all for this video. But to sort of give you a sense of what's happening in the courts regarding this matter, this petition was filed only yesterday. Therefore, the court has not yet listed this matter for hearing. However, it will be my my hope that whenever the court decides to hear this matter, that they should dismiss this case on the grounds that I have mentioned. And also, lastly, as law students, we should keep in mind that these, I would say, fancy claims of rule of law and arbitrariness under Article 14, when there is no backing for the same under the law, ought to be deprecated and condemned. Thank you.